Welcome to Estate Planning Essentials. I'm your host, Freeman Lindy, certified financial planner. And before we get started, let me ask you a question. Where are your assets going to go in the end? To your children, grandchildren? Are you sure about that? To your churches and charities? All of it? Estate planning will ensure that where you want your assets to go, that what you want to have happen when you pass away will happen. So what is estate planning? Who is it for? And there's this big myth out there that estate planning is for rich people, that only rich people with lots and lots of money need estate planning. But the truth is that without proper assets, without proper estate planning, much of your assets may end up in the hands of the government, attorneys, or going to fees. And so estate planning is for everyone, right? Anyone who has any assets, anyone who has any money at all, and who's going to die, which is pretty much everyone, needs estate planning. And so today what we're going to talk about in this Essentials of Estate Planning workshop is, first of all, 4 problems that we're trying to avoid by using estate planning. Then we're going to talk about how a will is insufficient, right? Most people know that they should get a will, and they think that if they have a will, then their estate planning is good. But that's not true. And so we want to cover why a will is not enough. Then we want to cover some no lawyer, no government strategies for ensuring your assets go to whom you want to go to, right? I'm not an attorney. I don't have, something to sell you. We're trying to get you to be in the best place possible. So again, no lawyer, no government ways of making sure that you can pass on your assets to whom you want. Then we're going to cover essential documents everyone needs, important people that you need to nominate, and some cost-effective options. So let's jump right into it. And of course, get the workbook if you haven't yet. If you signed up for this workshop via Retire Mentorship by being part of our membership community, then you will have gotten the workbook emailed to you. And so you can just check that email that you got today probably, and that'll be a direct link in there. Otherwise, of course, you can log in for it. If you're not a Retire member, click the link in the description. You can grab that. Retire Membership is a free community that you can be a part of. It doesn't cost you anything, and allows you to get some of these workbooks. You're going to follow along in there. Anytime you see underlined words in the presentation, that's a blank space in that workbook that you can fill out. So we're going to cover a lot, and so you're going to want to have those notes, those great takeaways and all of that, and that's going to be the best way to do it. Finally, if you're new to us and you just found this on YouTube, my main source is a podcast called the Retire Mentorship Podcast. It's your mentor to and through retirement, helping you retire successfully and stay successfully retired. You can listen to it on all the major podcast platforms or at retirementorship.com. And then lastly, before we officially get started, this is not legal advice, right? I'm not an attorney. I'm not licensed to give legal advice, either here in Wisconsin or anywhere else. And so this is just education, right? We just want to teach you some different things that you need to know, right? And so the other thing is that the state law is state specific, right? So I'm in Wisconsin. Everything that I'm talking about applies to Wisconsin, applies to most states, and I maybe even all states for a lot of it, but I don't know because it's state specific, and I don't know the laws in Louisiana or in California and all of these. So you want to seek specific legal advice from someone who knows your situation and is licensed in your state to give legal advice, and this is not that, right? So hopefully, right, we can just enjoy the education without having to do too much more disclaiming, but we got to get that out there right away. So what is the goal of estate planning? If we're talking about essentials, things that you really need, what is the goal for estate planning? And really, again, it's not just for the rich, but the goal is to transfer your assets to whom you want with as little interference as possible, right? The goal of estate planning is to transfer your assets to whom you want with as little interference as possible. And there's going to be 4 problems that we're trying to avoid, 4 ways that things can interfere with that process that estate planning is going to help us avoid. And these are problems that everyone is likely to avoid if we don't do something about it. And that's what estate planning is for. It's help us to avoid these problems. And of course, right, if we're talking about these, estate, meaning your estate planning and the things that happen to your estate are obviously after you pass away. And so for a lot of people, right, they're like, well, this is not a problem for me. I don't care. Like, I'm going to be dead. So really, these are more problems that your children are going to have to face. But really, at the end of the day, right, it's your responsibility to take care of these items. It's your assets. You know where you want it to go. Take responsibility, get it done. And we want to show you, first of all, again, the 4 problems and then some ways to deal with them, right? Number 1 is family fights. 4 problems to avoid. Number 1 is family fights, right? If you don't decide where everything goes, then your family may tear itself apart trying to figure it out, right? And again, a lot of people don't think, some people will jump right on there and be like, oh yeah, for sure, my family's going to fight over all kinds of stuff. There's going to be tons of drama. I know I need to fix this. Other people are like, what? My kids get along great. Everyone's, we all sing Kumbaya. We're all harmonious. That's not going to be a problem. We don't have issues with family fights. Let me just tell you this, right? Money does weird things to people when it's on the line. So just don't leave it to goodwill. Don't just assume like, oh yeah, they all get along, like no, there won't be any problems. No, like when there's money on the line, big, significant money, people get weird and it brings out the worst in people. And so let's just not do that. You need to decide what is going to happen. And if it doesn't cause a fight among them, it'll cause a fight internally because it may cause a huge burden. Right, if one of your kids ends up having to step up to be the executor and try to dig through all your junk and ask other people, maybe they're not fighting amongst themselves, but they're fighting internally because you are leaving them a huge headache and a huge burden. And let's not do that, right? If you love your family, if you love your kids, don't leave them fighting, don't leave them burdened by not taking care of these things. Number 2, the government deciding, right? If you don't decide where everything goes, the government will. Right? If you don't decide where everything goes, the government will. And really, when you think about it, right, who's the better steward of your assets? You earned them, you built them up, you've saved, you've done all these things over time. And who's the better manager? Who's the better steward of those assets? You or the government? Like, obviously you. So don't leave it up to them. Don't let the courts decide what should happen to all of your money, all of your assets, all your homes, your retirement accounts, your belongings, all these things. You should decide. Number 3, long delays, right? Long delays. Without estate planning, your assets may be locked up from 3 to 36 months, right? So we have all these things. Maybe you want your kids to get it. Maybe it's equal going to the kids. Maybe someone's going to charity. You've got, your church is doing some big initiative and you're resting easy knowing, hey, if anything were to happen to me, like they're going to be blessed right away and all these things. But if we don't do the proper estate planning, all that money could be locked up for months or even years before they can get it. And we don't want that to happen, right? So, but with a proper estate plan, 90% plus of everything you have can go immediately to whom you want it to go to, right? No delays at all, immediately there. And that's obviously much better. There's the time value of money, right? And so if your family's waiting years to get what's coming to them, that's not great. And if they can get it immediately, much better. And so that's what we want to do. And then fourthly, excessive fees, right? Unfortunately, in the U.S., dying is not free, right? You cannot die for free. There's always going to be some fees, some costs, just in administration and all that. A proper estate planning will cost most people, right, between $500 and $2,500. Obviously, there's people with very complex issues, big complex cases that'll cost them much more than that and to get good estate planning done. But most people, again, this is the kind of estate plan that's for everyone. Most people can get it done for between $500 and $2,500. But improper or no estate planning could cost, again, that same majority of people anywhere from $5,000 to $50,000. Right? Huge, massive difference in cost between you planning it yourself and you leaving it to chance and letting all this extra money go to the government, to fees, and to attorneys. And so you cannot, we just can't, we're not going to ever do it for free, but let's avoid the excessive fees that can come from not doing it all. And when you pull all those things together, right? Family fights, long delays, excessive fees, and the government deciding, like, it becomes very clear that estate planning is something that you want to do. You should do, and let's not leave it up to the rest of these. So what happens exactly to all your stuff when you die, right? What is the process of passing? Well, when you pass away, right, without planning, your assets go into probate, right? And probate is this court-supervised process where they transfer everything that you have to whom you want it to, right? To anyone who's entitled to receive them. And there's a whole order for that. And it goes, so like if you don't do any estate planning, it's all going to go to probate. And then they total up everything. They say, hey, who's entitled to any of this money and who should get it first? And the order that goes in is first, it'll pay out for your final expenses, right? To put you in the ground, funeral, bearer plot, all those things if you haven't done those things yet. And then number 2, it'll go out to attorney's fees. It's for attorneys that are helping you with probate and all of that. And you can tell attorneys wrote the laws because they made sure they were second in line to get any money. And then it will go to creditors. Right, anybody that you owe money to, any debts that you have, pay all those back first, right? And then only after all those things are satisfied will any remaining money go to your heirs, to your beneficiaries, to your children, charities, any of those things. And so probate is this court, supervised process to make sure that there's an orderly transfer of assets to whomever you want. Now, it typically takes anywhere from 6 to 18 months for this process to be completed, right? And for the final money to be paid out to the children or charities or those things at the end. But it can take years, especially if there's any conflicts or if people disagree or they're trying to challenge the will or anything like that. It can take a really long time. So what will happen, right? And got that in italics because obviously we have a will, right? Without a will, if you don't have a will at all, your family will face all 4 problems. Right? There's going to be big problems. There's going to be big family fights because you haven't decided anything and they need to decide it all. There's going to be, the court's going to have to decide it in that probate process, right? The government's going to have to decide. You're going to have a long delays. It's going to take as long as possible if you don't have a will. And there's going to be lots of fees going to the attorneys and stuff to help them through this and the government and all of this. So you will suffer all the problems if we don't have a will. And so a well-written and communicated will can help with the family fights and the government deciding. Right? If you've written it well and you've communicated it to your kids, right? If you don't communicate it to your kids, if you just leave it all in secret and surprise, now you know what you get and what you don't get and all that, then you can still have some family fights. But if you've written it well and you've communicated that to kids know what they're getting, it's written into your will, you can definitely avoid the first 2. But a poorly written will, right, or one that's surprising, is not going to help us avoid those things. And so that's and we'll talk about that later. It's a critical part of estate planning is actually communicating with the people that you're leaving money to. So you do need a will, right? You do need one. And so we're going to talk about why you don't need one in a little bit, or why it won't do and why it's not enough. It's insufficient, like we talked about at the beginning, right? But you do at least need one. So what a will and will not do for us is these things, right? So a will basically tells a court what your wishes are, right? Think about it like this, right? I hope this will happen. When I die, I hope this will happen. And you're writing all those things that you hope will happen in your will, right? It's your wishes, it's your will, and it's telling the probate court what you want. So when the judge sits down and reviews your case, he says, man, he's got all this stuff, he's got all these kids, wonder what we should do with this. Well, let's see what he wanted to do with it. And that brings up his will. It's like, okay, great. So that's what a will is. A will does not avoid probate, though, right? That is what it is. So you can't just will all your stuff to your kids and then they just take it. It still has to go through that probate process. It still has to be locked up for at least 6 months, maybe up to 18 or 24 or 36 months. And so it just doesn't avoid that, right? And here's the other thing that I think a lot of people don't know is that probating a will, right? Running a will through probate, that's a public process. And so whatever you put in your will, that's all now public information. You can look up people's wills when they pass away. And so if you're leaving a bunch of stuff to your kids or to charities or to other things, like anything you write in that will after you die is all public information to literally anyone. Creepers, other family members, people who are left out, all these things. And so it's very public, can be a very public process. And really when it comes down to the asset side of estate planning, a will is the worst way to transfer assets. A will is the worst way to transfer assets because it doesn't avoid the fees, it doesn't avoid the delays, and it's such a public process. So if we have all these problems with a will, what is it good for? Right? It's not absolutely nothing, fortunately, otherwise we wouldn't say that people still need them. So a will really is best for, one, naming that personal representative or executor, right? A lot of states have gone away from calling it an executor and calling it a personal representative. And that's the person, or in some cases an institution, right? A trust company or something like that, that you name that's going to monitor and execute the terms of the will. So whatever you want to have happen, right? Somebody still needs to oversee that from your side of the perspective, right? The court's going to oversee it, but they need someone advocating on your behalf since you can't be there and saying, hey, so-and-so wanted this to happen, here it is. And they're just going to make sure that all that gets pushed through. You also nominate a guardian in your will. If you have minor children, right, that's going to be the person that's going to take care of those children when you pass away. So especially if you have kids still. If you have minor kids in the home, like I do, right? I've got a 1-year-old and a 3-year-old. You absolutely need a will. You need to name that guardian. You need to decide, like, hey, obviously, like, if you're married, like, if something happens to one of you, the other one will obviously take over. But what if something happens to both of you? Then who gets the kids, right? And a lot of times it's not so much like nobody wants them. It's that like both parents and a sibling and all these things want your kids and would take them. And they're fighting over them and all these things. And especially if people live at a distance or all these things, there could be big problems, big family fights. And so especially if you have minor kids, you need a will. So I think as you get older, right, as you're getting into retirement and aging, the first part of that is really important, the executor part, because you're much more likely to actually pass away and need someone to take care of that. And when you're younger, the guardian part of the will is much more important. But either way, basically everyone needs a will and should have one. And it's also good for distributing personal items, right? Things that you can't do. Some of the other things we're talking about later, you got a special painting or a gun collection or something like that, and you want specific things to go to specific people. Again, communicate that first with them ahead of time, and then put it in your will to tell the courts, yep, I officially wanted these people to get them. Let them have it. Right? So those are the 3 things that a will is really good for. It's not good for passing assets. It's not good for any of these other things, but those are the things that you should have a will for. So why is it then that for so many people they think that a will is enough? Why do we only need a will in so many people's minds? Well, I think there are 2 main culprits for why people think that a will is enough, for why people will just get a will and then they think they're good to go. And the first one is Hollywood, right? We've got like these reading of the will scenes. Like, I don't know if you've ever seen Knives Out from 2019. There's a bunch of other movies like this, right? But someone dies, they get the whole family together, the attorney comes out and they're going to read the will. And, hopefully there's a bunch of drama and stuff because it's a movie. But that's kind of what people think that's what estate planning is, right? You do a will, you come together, they read it, you figure out who gets what, and then you're good to go. But no, again, there's that whole probate process. It's all public. It takes forever. There's a lot of fees. And there you go. Right. And then I think the other thing that we hear about a lot is similar in the same vein. You hear, right, of celebrities passing away without a will, right? Michael Jackson, right, famously millions and millions, worth millions or hundreds of millions, I don't know, however much he had, right? Millions of dollars, didn't have a will, had literally zero estate planning done. And what do you hear every time these celebrities pass away, right? Oh, he passed away without a will. He passed away without a will, which is bad, right? That's what it's called, right? Dying intestate means dying without a will. And it is a big problem, right? But that kind of message makes people think, well, the obvious answer then is to just get a will and then you're good to go. And so that's one reason, one of the culprits of us thinking that a will is enough. But the other one is attorneys. And for a lot of people, and a lot of attorneys, they're very well intentioned, and they're just, they'll examine the common person and say, well, look, your situation is too simple. Like, we don't need a trust, we don't need all these other things. You just get a will, and you'll be good to go. I can do a will for $1,000, or I can do a trust for $10,000. And Mr. and Mrs. Client, your situation is very simple, so I don't want to charge you $10,000 for the trust. Let's just do $1,000 for the will. But here's the thing, right? And again, I'm not making this up. Like, I've learned this from attorneys. And so and obviously not everyone's this way, but I've learned from attorneys that some of them, there's actually a business process where they will specifically only recommend a will because they make way more money on the probate process than they do on writing the legal documents. Right? They can write a will for $1,000, they can write a trust for $10,000, or if you only have a will, like, and someone passes away and they have their will, and then who knows the legal process, right? Who wants to deal with this? And so they say, well, who made this will? Oh, so and so firm, right? Hancock and John Hancock firm made this will, and so they go to the firms like, oh, don't worry, like, yep, we can help you with this. Probate's very long, it's very complicated, it's very extensive, but we'll be there every step of the way to help you through this. And don't worry, the estate will pay for all the fees for us for helping you through this. It's not, don't worry, it won't cost you a penny. The estate will pay for all of it. Right? And for like a little bit before people's inheritances are real to them, some of it's like monopoly money, right? When they don't really know, especially if, again, none of it's been communicated. They don't really know exactly what their parents have, where it is, what it's worth, what they owe, any of these kind of things. And so there's kind of just this pool of monopoly money, and maybe they know they're getting something at the end. And so it's very easy for attorneys and firms and stuff to charge a lot of money to help people in the probate process because they're charging it to the estate. And it seems like monopoly money, doesn't seem like real money. And at the very end, they say, hey, good news. And again, right, final expenses first, attorneys second, get paid. then creditors, and then at the end, right? So then all those things are paid. Then they come back and say, hey, good news, like here's your third, here's your half, here's your fourth, and everyone's happy. But in the meantime, the attorney, the firm has charged the estate $20, $30, $40, $50,000 in probate fees. And so again, this is where that excessive fee thing comes in. Not only does it take a lot longer, it can cost a lot more, and a lot of people just don't know it. So it's a business model. I don't know, not everybody does it that way, but certainly a lot of firms do, as I've been told by attorneys. So that's again another culprit of why a lot of people think that they only need a will. And then another one that just occurred to me just now. You also get some of these gurus out there that'll say like, oh, just get a will. You don't really need a trust. Like trusts just get complicated and all these things. But we'll show you some strategies of how you can use trusts and use some of these other things and make it as simple as possible and straightforward and as easy to manage as possible that kind of get around some of those things as well. So if this probate process is so long and so complicated and costs so much in fees to go through, how do we avoid it? Right? How do we avoid probate? And especially, how can we do it without a lawyer? Right? So there's going to be a few, these four methods. These are the superior ways of transferring assets. Right? Well, a will is not the place to transfer assets. These four ways are going to be the ways that you want to do it. And all of these starred ones are going to be that you don't need an attorney to do that. So the first one's going to be joint accounts. Right? Anybody that is joint on an account with you, it'll pass right to that other person. Beneficiaries, TODs and PODs. I'm going to go through all these. And finally, a trust. So first of all, joint accounts, right? Assets are automatically going to transfer to a joint account holder. If you have two people on an account, one of them passes away, the surviving one gets everything automatically, right? This is obviously best for spouses. You're joint on the deed of your home. You're joint on your checking account, savings accounts, all these different things, right? And so that way, if one of you passes away, then the other one gets all of it, right? And it can also be used for like adult children who are now kind of stepping into that role of caretaker a little bit. Maybe you're really getting up there in years, and so you put one of your joint kids in there so they can help you manage your finances and everything. But you don't do this with like your minor kids, right? You're like, oh, I really want to make sure my kids get stuff, so I'm going to put them on this joint. All these things are with your 18-year-old kid or something like that, right? And all of a sudden, it's a good way to lose all the money in your account because all of a sudden you realize your 18-year-old kid spent it all right out of your account. So, joint accounts are a great way in some circumstances, but not in everything. And so for each of these, for the different types of accounts, right, you can be joint on banking and brokerage accounts. You can be joint on real estate, right, on your home and the other real estate you have. But you can't be joint on retirement accounts, right? IRAs, individual retirement accounts, they're for individuals only. 401ks, same thing, all these. So you can't put someone joint on those. And you can't put someone joint on life insurance, right? Just it's on one life. If that person dies, it pays out. If that person doesn't die, it's not paid out, right? And so you can put joint accounts on some things, but not on other things. And most people's assets, when they're young, if they've got the right amount of life insurance, that's going to be worth a lot. And as you're older, like your retirement accounts, that's going to be worth the bulk of most people's assets. And so obviously joint accounts is not going to solve for the majority of your assets. Do you need an attorney for joint accounts? Obviously not. Beneficiaries, that's the next one, right? So assets will automatically be transferred to named beneficiaries, right? It happens automatically. You don't need probate. If you pass away and you've got, a big IRA and you've named your, say your spouse is already gone, it's just you and your last one passed away and your kids are named, half and half, two kids, half and half on that IRA. When you pass away, they're going to work directly with that custodian, Fidelity, Vanguard, Schwab, whoever it is. And they'll provide death certificate, fill out the form, and then they'll pass that money straight to your kids. Doesn't even deal with the court. Probate's not involved at all. No attorneys, no anything, right? And it's automatic. Like as soon as they fill out the form, as soon as you get that death certificate, fill out the forms and all that, that money can be sent straight to the beneficiaries. So it's great. All right. So, but again, I've said this before in the podcast, and I want to really make sure that you understand this here, that beneficiaries trump the will. Full stop. Right? Beneficiaries trump the will. So if you've said in your will, like, yeah, I want all my stuff to be split, a third amongst my three kids. But then you have something different on the beneficiary designations of your life insurance or your retirement accounts. They have to follow the beneficiary, not your will. The will, they don't even care about your will. And again, that's why wills are so, at least for transferring assets, almost useless. Because and this happens a lot where people will have, they have their spouse on it and then maybe they get divorced. And so they change their will and make sure everything goes straight to their kids and they take the spouse off the will and all that. But they forget to change their beneficiaries. And and then they pass away and the kids are like, hey, we were supposed to get all this. And Schwab's like, I'm sorry, this woman, this ex-spouse, according to you, now ex, doesn't matter. They're beneficiaries on the account. They're getting all of it. And so you got to make sure that you're always updating your beneficiaries to what you want, because they will trump the will. And you need to name primary and secondary, right? So for most people, if they're married, your spouse is going to be primary. My wife is primary in everything that I have. And then you're going to want secondaries, right? What happens if we're both gone, right? If me and my wife both get hit by a car or have some accident on a trip or something like that, then who gets it? Again, that's usually kids or trusts or some of these other things that we'll talk about. So a lot of people have primaries, and a lot of people, when you sign up for an account, they'll force you to do a primary, but they won't force you to do a secondary, but you should have both on all accounts that can take them. You can't do beneficiaries on banking and brokerage accounts, right? So if you have non-retirement investment accounts or any bank accounts, those kind of things, you can't do beneficiaries on those. You can't do beneficiaries on real estate. There's no line for a beneficiary on the deed to your house. But you can do it on retirement accounts, IRAs, 401ks, Roth IRAs, HSAs. For this purpose, are considered retirement accounts. You can do beneficiaries on those. And you can do it obviously on your life insurance and your term life insurance. Hopefully you don't have permanent, different subject for a different day. But those are things that you can then pass automatically right at death. And again, do these require an attorney? No, they don't. You just got to make sure you do them and put them on all the accounts that are possible. You just got to do the work, right? Because those other accounts can't do it, that's where you can, though, have these either a transfer on death or a payable on death, right? A TOD or a POD. And it's the same thing, right? Assets automatically transfer to the person named. And that's a typo there, but the person named as the transfer on death, right? And so this works for banking and brokerage accounts. That's the caveat. That's the workaround. You can't put a beneficiary on a non-retirement investment account, but you can just put a TOD on it so that when you die, it transfers at death to the person that you named. So that's a good way just to basically do those other two, right? So you had, we had beneficiaries, get the bottom two, and TODs, get the top two. And again, do you need an attorney? No, you don't. And this is really important on your house too. A lot of people don't think about that, but if you're passing away and you have your house, right, most likely it's going to get sold, but if they can't sell it until after probate closes, that's a problem, right? Especially if you still owe money on it, or even if you don't, right, you're still paying property taxes. So if your house is going to get locked up for 16 to 18, maybe even longer, 16, 18 months, that's 16, 18 months of basically your estate having to pay property taxes, insurance, and mortgage if you haven't paid it off. That's all going to be money that's flushed out of your estate. There's extra fees, there's excess costs, all these things, right? So instead, if they're just going to sell it anyways, you're just delaying that process for 6 to 18 months. But if you have a TOD on it, right? If you have a transfer of death deed, it's what it's called, a TOD deed on that house, and that's something that's a form that you can get from usually your county registrar. You fill it out, you have to go file it. Usually you have to pay some fee to get it filed in the county that you live, and then they stick that on with the deed. And then when you die, it transfers on death to your beneficiaries. You can name it straight to your kids. And then if they don't want it, right, if they don't even want it, they can put it on the market right away. And there's none of those delays. And so your estate, your kids will potentially save hundreds, maybe thousands of dollars just from this one thing alone, right? Getting a TOD deed on your home. Bigger the home, obviously, the more savings that's going to be. So it's super important. Again, and you don't need an attorney for this. You just got to go do it. That's it, right? And then lastly, a trust, right? Now, what a trust is, that's a legal entity that can own property. So you're creating a legal entity with the state. You can even get an IRS tax number for it and everything, so they can file taxes, all these things. So it's kind of like a person, but it's its own legal entity, and it can own property. And it allows you to control assets and transfers beyond death, right? And so if you don't, if you just want everything going right at your death, hey, I want everything going out to my kids, these charities, whatever else, then maybe you don't need a trust. But if you want any delays in it, if you want to control any of it afterwards, do any of these things, then a trust is a great way to do that, because you can write whatever you want into a trust. They can obviously get very complex, or they can get simple. You can have a simple trust that's just like, hey, I just want to do these few things. We'll talk about an example in a little bit. And obviously, if you want really complex things, you can do that as well. And so, you can put banking brokerage accounts inside of trusts. You can put real estate inside of trusts. You can also do retirement and life insurance in trust, have a trust be the beneficiaries. Big cautions there, though. That's probably not the best thing to do. You're probably better off naming those straight to beneficiaries, except for with some exceptions. So there's sometimes you definitely want to, and other times you definitely don't. So just that's why we got the kind of exclamation point there. And do you need an attorney? Yes. And asterisk there because you don't. There's other ways to get a trust, but you do need some legal firm to obviously create these. And you can't, I wouldn't, you could write your own trust. I wouldn't recommend it, right? You're going to want to have somebody who knows what they're doing, who can have all the language that they need in that to get there. So what's like a simple estate strategy for most people, right? Again, if you got lots of wealth or very complex family dynamics, you're trying to disinherit someone, or someone's already has like mental capacity issues or any of these other things, like you're going to want to do, more specific things, and you're probably going to need like an attorney in your state to ask all these questions for and get real legal advice. But for most people, a good simple estate, simple, not simplistic, but simple, effective strategy would be to get a will, to name your executor or guardian, and to make special bequests, right? Special, hey, we want, this artwork to go here and this gun collection to go there, those types of things, right? That's what you get a will for. So you get the will, get it done. You definitely need that. But then do not pass any assets or accounts via the will, because they will be public. Right, so you just don't even name any, other than the personal belongings and specific things like that. Like, don't name any accounts, any assets, anything in the will. Just leave it out entirely, because then it won't be public. Instead, pass 90 to 95% of your assets through beneficiaries and TODs. Right, and that avoids the public probate, and you can get immediately. It avoids family fights because it's going straight to them. They can't fight about it. It is the way that it is. As long as you have it updated, right? If you don't have it updated, that's a big problem, especially if it's got X's or those types of things. But if they're updated and accurate, then you can't fight over it because it just happens. There is no government deciding, because again, it just happens. There is no delays because it happens immediately, and there is no fees. Like, you can do this for free, right? And so beneficiaries, TODs, they conquer all four of those. And so in your estate plan, right, make sure you have those, and you want to pass 90 to 95% of your assets straight to your beneficiaries using those things. But I wouldn't do everything, and you can technically send 100% of your estate straight out the door right away at your death, right? You can put TODs, beneficiaries on everything, but I wouldn't, right? And here's why, right? Keep some cash in the bank for probate, because you're always going to owe a little bit of something. You're always going to have some final expenses, something or other, right? And you also need to leave as much as you need to cover any debts, and don't send those straight out. So if you owe a ton on your mortgage, you don't necessarily want to TOD that, or to put that into a trust, or to beneficiary, TOD it straight out to kids or those kind of things, because like, they're gonna have to pay that. You're gonna have to pay that back off, right? Or if you have a whole bunch of credit card debt, like, they're gonna come after that in probate still, whether all the money's been distributed or not. And so then you're gonna have this kind of clawback where the state then has to go back on, the courts have to go back out and say, hey, we need this money back because your folks owe money, right? That you can't get away from your debts, from your obligations, by sending everything out via TODs and beneficiaries. So it's not an escape plan. So you want to keep enough cash on hand for probate and enough cash on hand for any debts or things that don't TOD everything. But over and above that, then you can send, again, 90 to 95% straight there, and just leave a little bit in, and they can get that last 5-10%, in 6 to 18 months. As long as they're getting 90-95% right away, right? I'm sure your kids or charities can wait 6 to 18 months for that last 5 or 10%. No, and then you want to maybe consider a trust, right? If you want more control, if you want to do things beyond the grave. So, a lot of people who don't have kids anymore, they don't necessarily need a trust anymore. But if you want more control, again, you want to control the timing of it, you want to do special things with it, then you would consider a trust. And you can do a living trust, right? Or a revocable trust, as it's often called. And that can be changed any time. So you change the languages of it, you can change what goes in there. And this is where some people, including like Dave Ramsey and stuff, say like, yeah, you don't, unless you're really complicated, you don't need a trust, right? You can just do these other things, because then it makes it complicated, and you always got to sign as a trustee, and it becomes difficult to manage a trust versus just managing your own money. But this can be avoided, if you fund the trust through TODs and beneficiaries instead of actually putting the money into the trust. It's a valid point, right? Like, if you create a trust, and then some people say, oh, and you got to fund the trust, like, make sure you fund the trust, otherwise it's just a big expensive piece of paper. Like, put your house in there, put your bank accounts and your brokerage accounts, and your put everything in there right away and make sure it gets funded. And then it does create that issue of, it is difficult to manage it then, and much more difficult than just managing your own house or your own bank accounts that you're directly on. But what you can do is you can use TODs and beneficiaries to point everything towards a trust only after you die. And then you get all the benefits of the trust, all the control, all the deferral, all the privateness of a trust. You get all the benefits with none of the hassle of currently managing it, right? And so that's a good way to get that done. Simple strategy. Again, a lot of people are going to have complex cases. They're going to need more than this. But for most people, that's a really good strategy to do. Here's some addendums. If you're a family with minor kids, or maybe your grandparents and your kids have minor kids, right? And this is very important. And if you don't have kids anymore or minor kids anymore, don't brush over this, because if your kids have kids and you have grandkids and stuff, you're going to want to make sure they take care of this, right? That they've taken care of their estate plan, that you know where your grandkids are going. And that's something I think you could communicate, especially if you have good relationships in the family. Like as a grandparent, I think I would want to know. My parents know where my kids are going. And it's just good family communication. So minor children will require a conservator or a financial guardian, depending on what state you live in. They'll call it one thing or another. And they're going to require that, right? Because minor children can't manage their own money. And if you pass away and you're leaving them hundreds of thousands of dollars in life insurance or whatever else, right? They can't manage all that when they're 5 or 7 or 12. And so they're going to require somebody to be named to control that money for them. But in all states, right, the children will then get full control of that money at the age of majority, which is 18 or 21. In pretty much all states, it's one or the other. In Wisconsin here, it's 21. But in a lot of states, it's even 18. And so, yes, they're going to have a financial guardian managing it for them in the meantime. But the moment they hit 18, the moment they hit 21, they get full control. So let me ask you a question. Are people financially mature at 18 or 21? For the most part, no, right? They're just not. We know a lot of 30-year-olds that are not financially mature, a lot of 50-year-olds who are not financially mature. But certainly, someone who's still in college who just got their first real job, they're not going to be able to handle hundreds of thousands or millions of dollars all at once, right? And I'll talk about this later, right? But I got $2 million of life insurance on myself and 2 kids only so far. And plus other assets. And so even without the other assets, right? The fact that they're each going to get $1 million each, tax-free, that will then grow for them between now and again, they're 1 and 3. And so, by 21, that's, there's an 18 years. So it's going to be much more than $1 million. I hope my kids grow up to be mature, but they're not going to be mature enough to handle $1 million+ bucks right at 21. There you go. There's $1 million in your bank account. That's not a good idea, right? They're just not going to be able to handle that well. So we can use a living trust then. They can hold assets and invest them, right? They're going to keep invested. It's not just going to sit in a bank. They can open trust investment accounts and keep that money invested. And you can hold those assets until you decide when the kids get them, instead of giving 100% of that to them at 18 or 21. And so, that trust then can pay income to the guardian, right? We talked about the guardian earlier. That's the person that you name to take care of your kids. That's my brother. And for me, right, my brother, he's got a wife, they got kids. And so my kids would go with them. But I don't want this to be a burden on them. So we've got life insurance. I'm taking care of my own family, right? I'm not leaving that financial burden to someone else. So I love that they're going to be the guardians, take care of my kids. But I want to financially support my own kids. So have the right amount of life insurance. We've got the estate plan figured out. And so that money's going to go into a trust and it can pay out to them. And you can, to the guardians, for the care of my children, for what is called HEMS, right? Health, education, maintenance, and support. So, education, whether that be they're going to a private school, which whatever, it's up to you, right? You can do whatever you want, or they're going to college someday, right? You can pay that out to them for that. Any health issues, obviously you want them to be able to have that. Any maintenance support, just general, maybe a monthly stipend for groceries and all these things, right? Take care of your kids financially through good estate and life insurance planning. And then the trust can then release lump sums to them at certain intervals. So instead of them getting all of them in Wisconsin, right, getting 100% of it at age 21, you can stagger it out. And so a common one, the one that we use a lot is that, and the one that I personally use, is that my kids will get 1/3 of that lump sum then at age 25 or the completion of higher education. Right? They complete a 4-year degree or a trade school or something like that. So if they do something with them, right? I don't want to create trust fund babies. Like, I'm not into that, right? And so they don't get the money until they're either 25, they're a little older to be able to manage it well, or they, complete a job and they're going to get a real job and a real career and do some of those things, right? And then they can get some at age 30 and then the rest at age 35. And again, it'll be invested the whole way. And so they actually should get larger sums, larger dollar amounts at those periods beyond. But, that way it staggers it out and it hopefully allows them to be more and more mature as they get those funds. Make them prove that they're able to manage that first third well before you give them. And you can even put in their stuff for the trustee, the person who's going to manage the trust, to say like, hey, if they're not financially responsible, like if you have issues like that, right? And you've got, maybe your kids are already a little bit older and they're exhibiting really immature behavior, and you can write in there like, hey, they need to have a stable job, not be on drugs, any of these other things before they get any of the money. And if you don't put that stuff on there, again, they're going to get it at age 21, at age 18, regardless of how bad they're choosing to live their lives. So again, gives you some control from beyond the grave. So yeah, that strategy alone, it's what we use with a lot of our clients. Though having those things in place will really suffice for a majority of people, I would say. But what if you're still alive, right? All these things are for when you die, especially when you and your spouse die. Like, what happens to your kids? What happens to your stuff? What if you're still alive and you can't act, right? You get in a car, like me and my wife get in a car accident, I die, she's still alive, but she's in a coma and she can't act. Well, that's what's called incapacitated, right? Where you're still alive, you're not dead yet, but you can't make any decisions for yourself, you can't act for yourself, you can't do any of these things. So that's where you're going to need a power of attorney, right? For both finances and for healthcare. And that's somebody who's going to be able to step in and make decisions for you, do things for you, pay your bills for you, all these different things. And again, usually it's your spouse, if you're married, as your primary power of attorney. But then you're going to need to name contingent ones, right? Because again, in that scenario, right, I die, so now I can't be the power of attorney for my wife. So then who's it going to be? And a lot of times it's named separately in most states. And you might want to name someone to healthcare power of attorney who's got, more loving, maybe knows more about the health sides, but maybe they don't know jack about money. And so you want to name someone more financially literate, and better manager of money on the financial side. It can be the same person, but you might decide to split that out, and do two separate. And again, this is really important, and people often don't think they need to do this and name their spouse as primary, but you do. And because we've seen cases where this didn't happen. I can't remember the name of the case, but you probably, if I tell you about it, you might remember, right? Where there's one in, I think, Texas or something like that, where a woman became a vegetable and was on a life support for months and months, maybe even years. And finally, the husband wanted to pull the plug and was like, look, she's not coming back. She's gone. I've already lost my wife. Like, it's just we're keeping her body alive, even though she's not there. Like, I think it's time to let her go. And her parents, though, did not want that to happen, right? Like, no, we don't want, like, it's our daughter. Like, we can't just let her die. And so then it became this huge court fight, became very public. It was national news for weeks and months. And they had a fight over, like, who's got the right here, the parents or the spouse, and like who can do this. And all that can be just eliminated if you've named a health power of attorney, you've done your health directive and these other things. So you need to do that. You need to name your spouse if that's who you want it as your thing. And then you're also going to want to make as many healthcare decisions for yourself as you can with an advanced directive, or sometimes called a living will or health directive. It's all those names. They all mean the same thing, which is basically like, hey, what do you want to have happen to yourself? Because you don't want to leave that burden to someone else without leaving instructions or without making some of those decisions for yourself, right? And so, like, do you want to be kept alive on a feeding tube or on life support? Do you want to be committed to a nursing home? Do you want CPR done to you, and some of these other things, right? Like, don't let your kids or your spouse have to make that decision for you. You make your own decisions on what you want to have happen in those health regards. So a lot of the major issues can be decided. You can decide those for yourself, and then you name the healthcare power of attorney to step in, and any of those other ones that are not specifically named, that's going to be the things that they come in and make those decisions for you when you're not able to. So just to kind of wrap up here, to kind of summarize a lot of these things that we've talked about, right? Some essential estate strategies, right? First of all, beneficiary designations, right? These past retirement accounts and life insurance directly to named individual entities. You need these. You need to have your beneficiaries done, primary and secondary. You have to get those done. That's going to be one of your biggest estate planning things. So go check all your accounts. Make sure that you have both of those done, a primary and at least one contingent, that next level down. So if something already happened to your primary, then they still know who to pay that out to. Because if you named a primary only, right, if you named your spouse on your 401k because you had to, because it wouldn't let you set it up without naming at least a primary, but then you didn't name your kids, well, now the 401k goes into probate if you both pass away at the same time. Right. And so all those benefits of being able to pass it straight to the beneficiary, nope. And there's a whole bunch of issues when retirement accounts go into probate. So just don't do it. Like, get that contingent beneficiary, go do it right after this. Go log into all your accounts. Make sure you have it. You do nothing else from watching this. Go make sure that all your beneficiaries are completed. And then transfer on death. And for any brokerage accounts, if you've got big non-retirement investment accounts, you can do a TOD on those. And you can do a transfer on death deed for your house. And that's going to, again, pass those straight to those individuals. So if you do nothing else other than beneficiaries, go get TODs on the relevant accounts that you need. And again, this is great, right? Because you're just not going to get these kind of things from attorneys. Because again, they either make money from writing the documents or from doing the probate. And you can do both of these things without them at all. And so that's where we're stepping in and just helping you. Again, strategies over products. We're all about that, right? The best things in life can be done with good strategies, not good products. And so you're going to want to make sure that you have those done. And just as a side note, quick, if you're doing any donating to charity, or if when you pass away, you want things to go to charity, to your churches, those kind of things, then traditional IRAs, putting that charity on as a beneficiary or as a contingent beneficiary on your IRAs is the best way to do that. Right? Because if you name them to your kids, don't name a charity in your will. Like, oh, I want such and such to go to my church, or such and such to go to the Red Cross or whatever. Like, don't name that in your will. Put it as a beneficiary on your accounts, in particular, your traditional retirement accounts. Because if you are sending those to your kids, right, then it's taxable money to your kids. You haven't paid any taxes on a traditional IRA. You haven't paid any taxes on a traditional 401k. And so, yes, you can benefit those to your kids, and then they become inherited IRAs or inherited 401ks, and they can get that, but then they still take that money out and pay taxes on that. If you beneficiary an IRA or 401k directly to a charity, neither you nor the beneficiaries pay any taxes. Charity gets 100% of that money tax-free because they're tax exempt, right? They don't pay taxes. And so don't name charities, don't name churches, don't name any of these things in your will. Put them as beneficiaries on your IRAs, and let, again, there's strategies about giving appreciated stock to charities, which is a good tax thing. We covered that a little bit in our reducing taxes in retirement workshop last month. That kind of goes away as an estate planning thing because you have a step up in basis, and so your kids wouldn't pay any taxes on that anyways. So IRAs are really the best thing to do to beneficiary out to charity. So there's some, you save a ton of taxes doing that one. So there you go. There's 3 strategies, right? Estate planning strategies that are essential and that you can do for free. You just got to go do them, right? You just got to plan it out, think it through, and go execute those things. Then you're going to need some essential estate people, right? Certain people that you're going to need to name and nominate to get some of this stuff done. Again, guardian, people who care for your children. If you've got minor children, you need a will so that you can nominate that guardian. Executor, right? Who's going to manage your affairs after you die? Trustee, who's going to manage that money in the trust? So if you make the trust, right, you're the grantor, you just establish this trust. Who's going to manage that and make sure that gets done in the future the way that you want it to do? You can name a person, or you can name, there's trust companies and things that will do it for you as well. And so that's going to be important, right? That financial power of attorney, or FPOA, and the healthcare power of attorney, the POA. Those are all people that you're going to want to nominate, that you're going to want to name, and make sure that you know who's going to be in control when you can't do it yourself, right? You decide who that should be. Don't let the government decide that for you. And then lastly, essential estate documents, right? The will, we talked about that, name the guardian and the executor. A trust, if it's not, essential only if you want to do these things, right? And if you want to keep your minor kids from getting it at age 18 or 21, or if you want more control, it's going to hold and control assets. A financial power of attorney, right? Naming who's going to take care of all your stuff if you're incapacitated. And one little thing on that, there's a durable financial power of attorney, and that's where, if you just name a non-durable financial power of attorney, then that's somebody that you want to have control of, right now, and just help you currently. But if you become incapacitated, then they no longer have that power, because they just assume, look, you only want them to have this power while you also were competent to be able to do it, but that goes away if you don't have that. So you probably want it to be a durable financial power of attorney, which means that if you're incapacitated, if you can no longer make those decisions, that's especially when you want them to be able to make it, right? So make sure it's durable if that's what you want. And then springing, means it only comes into effect when the event happens to you, right? And so you might name your spouse as a non-springing, as a current power of attorney, because you want your spouse to go ahead and sign for you or do whatever else. Or if you're aging, you might name a child as a non-springing power of attorney, because like right now you want them to be able to help you with your finances and do those kind of things. But if you're in your 40s or 50s and you've got some adult children that you're naming as power of attorney, like you don't want them to make decisions for you right now or be able to sign on your behalf right this second. And so you want that to be springing, which means that it only springs into effect in the event you become incapacitated. So a couple little caveats there. Again, if you need more advice on that, like you're going to have to talk to an attorney and get specific advice for your situation, but there's some educational bits there for you. And then again, your advance directive, what you want to have happen with your healthcare in certain situations, and that healthcare power of attorney to decide all the other ones. And then I would also do like an estate plan summary. I think that's an essential piece, right? That sums it up for your family, for your executor, because that is a lot of pieces, right? It's a lot of strategies, it's a lot of documents, it's a lot of people. And so having some kind of strategy is what we do for our clients, right? We give them a nice summary that explains like, hey, here's all the things, here's where everything is going. Again, we'll update our clients periodically, like, hey, by the way, like according to your estate plan, this is where everything's going. This is the amount of money that would go to each person. You're still okay with that? Do we need to do any updates to that? And so it's just good, makes it easy for them to manage that in the end. So what have I done, right? Like, this is not a do as I say, not as I do workshop. I'll just tell you this is what I've done, right? So one, I've done all those essentials, all three of those, the strategies, the people, the documents, that's all been completed. My brother is a guardian. Again, he's married. He's got kids the same age as my kids. So I don't want to name my parents and have them have to kind of restart with kids. I want them to be able to join into a family. If my brother has enough kids, we might name somebody else because there's just going to be too many kids under one roof. But as it stands now, he's the guardian. I also have, not in the will, because the will's public, but in my life insurance, I have a little bit, going out to them right away. Because if my 2 kids join their 3 kids, then all of a sudden they have 5, and their minivan's probably not going to cut it anymore, or they're going to need a bigger one or something like that. So I want, again, I'm going to take care of the finances of my kids with the trust, which we'll talk about in a second, but I also want to just bless them and say thank you for taking care of my kids. Here's some money for a bigger van or to move to a bigger house to accommodate or those kind of things. And that's just for them, right? So it's beneficiaries on my life insurance, which means it's tax-free. It's not income to them. It's not public. It's just named right in there. My cousin is the executor. He's also a financial advisor, so he knows this stuff. So he's the executor of my will and my wife's will, and he'd be the trustee of the trust. So yes, I do have a trust, right? I don't want my 2 beautiful daughters. I'm going to teach them to be financially responsible, right? It's kind of my job. But in the off chance that I pass away before I have that influence on them, I want to make sure that, one, they're taken care of through that HEMS function. It'll pay out to my brother. So my cousin, the trustee, can make sure that money's paid out regularly to the guardian, my brother, to care for all their expenses. And then they'll have that 1/3 each, 3 times a third at 25 or higher education at 30 and 35. And also incorporates any future children, right? And so I did it after the first one was born. So it's got language in there so that the second one is automatically included. If we have any more, those will also be automatically included. Fun fact, if you've named your kids directly as beneficiaries, right, then every time you have another child, you got to make sure you update your beneficiaries, because beneficiaries always trump a will, they trump everything else, right? And so if you have a third kid and you name your first 2 as 50-50, and your will and your trust or whatever say to incorporate it, but the beneficiaries are directly to your kids, and something happens to you, then your first 2 kids are still going to get half and half, and your third kid's going to get squat, like literally nothing. And the other 2 kids, like if they want, they don't have to. Legally, they don't have to, but if they want, they can gift a bunch of money over to make that third kid whole, but now you got gift taxes and all these other things. So that's a nightmare. So if you're naming kids directly and you're still having kids, you got to make sure you update your beneficiaries immediately after you have them. But if you've named a trust as a beneficiary and the trust automatically incorporates new kids, then you don't need to change anything, right? Because now it's all taken care of. So there's an extra fun strategy for you there. And so then my wife is named primary, obviously, on all my life insurance, on my retirement accounts, all these things. And then the trust is named as contingent beneficiary. So if we both go out at the same time, then all the money goes into the trust to be managed and distributed to the kids as necessary. At this stage of my life, right, younger, I've got way more in life insurance than I have in IRAs and whatnot. So the majority of that's going to be tax-free, pays out to the trust tax-free, and then it'll be managed in the trust by the trustee, again, who's an advisor, so he's going to know how to manage that well. And right, I got $2 million of 20-year level term on me. I got $1 million on my wife, who currently stays home with the kids. Still a huge economic benefit there, so we want to make sure there's plenty of stuff. So that's going to be $3 million plus our house and retirement accounts and all these things going into that trust, making sure that our kids are good to go, right? And that's a lot for 2 kids, but as we add more kids, hopefully that'll be sufficient. We update that. We look at that periodically to make sure that we're covered there. So that is actually how mine is set up. And then I also got, some of my IRAs going out to the church directly. That will change as the amount that I would want to go to a church goes out. You can change your beneficiaries as often as you want for free. So that's a great, you don't have to keep amending your will. You don't have to keep amending your trust. Just do those things with beneficiaries. You can change it as much as you want. But again, then we're getting that full tax-free benefit and being able to give more to the church then. So how do we get all this done, right? You're like, okay, we got essential strategies. You can do those for free. But if you need those documents, you need to make sure you officially nominate those people. Then how do you get that done? Well, one option, of course, is online document preparation. You can, Google some options there, like online will, online trusts. Those are going to cost anywhere from $100 to $600 I've seen. You can get some more expensive ones too, but certainly you can get them in that range for just some boilerplate documents to get it done, right? And that's going to be the pro of that. Obviously, it's very inexpensive. And this is where, again, hey, really anyone should do this. Even if you're like a college student and you've got just a little bit of, you're probably not watching this, but if your kids are a college student, right? And they got very little assets or whatever, you can still, for like $100, go get them a will, at least, to name an executor and some of these kind of things. But you can and should get this done. The cons, of course, is that you're getting very little guidance and education. And I think a lot of people are always wondering, did I do it right? Is this really going to hold up if it's just like an online will? It seems sketchy to some people. And so that's not going to be for everyone. I would say it's better than nothing. Right? Like nothing is horrible. And so even if you have some reservations about doing online, if you don't want to shell out the money for any of the other options, then at least do this, because it's better than nothing. Then of course you're going to hire an attorney. Those, $2,000 to $10,000 to get all these things done. That depends obviously on how complex your estate plan needs are, where you are in the country, right? La Crosse, Wisconsin is a lower cost area than certainly like New York or San Francisco. I don't know if you can get this done for $10,000 out there. But so depending on your area, that's going to cost different things. The pros are obviously that includes legal advice, which again, disclaimer, none of this is legal advice, right? This is just education. So I'm not even telling you what to do. These are just a bunch of options out there, right, for things that you can do. And so if you want the actual legal advice, like, hey, what should I in my situation do? Then hiring an attorney is the only way you're going to get that, right? All the online document prep things are going to be very clear. Hey, we do not provide legal advice. We just make the documents. That's it. Some of the cons, of course, are expensive. And I've also seen from a lot of firms that there's very little follow-up, right? They'll like write the documents and like, okay, yep, make sure you change your stuff, but they won't follow up and make sure. And I've seen a lot of people that have a very expensive, nice trust, but all their beneficiaries are still pointing the other way. And beneficiaries trump wills, they trump trusts, they trump all that stuff. And so if there isn't that follow-up to make sure that the whole estate plan is done and tidied up and buttoned off, then it doesn't matter. Right. And so that I've seen that as an issue. We can have just very expensive paperweight then at that point if nothing is actually coordinated outside of the actual documents. We didn't like that those were the only options that were out there, kind of this inexpensive, cheap version and the super expensive other option. So one thing that we did is we've actually partnered in my financial planning firm, La Crosse Financial Planning, we've actually partnered with a firm that specifically works with advisors to help their clients get their estate planning done. So this firm will create the documents. It's an outside firm. And so obviously I'm not writing legal documents, but they'll do that. They don't offer advice. They're saying, hey, if you as the advisor, if you do all the education, if you do all the, coordination, figure out who needs to go home and all these things, then we'll just write the documents and we can do that at a very good price, right? And so we include that in our services for financial planning. So we do comprehensive, we do everything financial for our clients, fee only, and estate planning and essential estate document. Right? If you fall into this category that we've talked about, where you just need the essential things, then that's included in there. If you're very complex or all these other things, right, then we're not gonna be able to do that for you. So then there's no additional fees for that. You're gonna get that Right along with, we can make as many updates even to the documents themselves as we need to without any additional fees. So obviously you're going to get some guidance, education, follow through, accountability, right? Making sure that we actually get all that stuff done and have everything point in the same direction. Really create the whole estate plan, not just estate documents. But of course, cons are that no legal advice is given or included, right? We don't do legal advice. I'm not licensed, as we talked about at the beginning. So lastly here, do it for the children, right? Do it for the children. Look, it is unloving to leave this undone. It is unloving to leave this undone. If you have assets, if you have children, if you have loved ones, then you need to get your estate planning done. Because if you don't, you're going to cause family fights. You're going to cause this burden of all the complexity of your kids. And I've helped clients work through cases where their parents didn't have a will, or even had a will, but it was just a will and didn't have anything else done, and work through 18 months of probate and fees and all. And it's just horrible. It's horrible. And so get it done. It is unloving to leave it undone. Do it for your kids. Don't settle them with this burden. And honestly, children are going to prefer less inheritance with a complete estate plan, right? If it comes down to, hey, your your two kids are each going to get $5,000 more in their inheritance, but they're going to have to work through all the headache of probate, and all those extra fees are just going to disappear anyways because you didn't do any of these things. They'd rather receive $5,000 less each, right? And have you pay an attorney $10,000 to take care of this than they would to get the maximum amount pre-fees, pre-attorneys, pre-headache, and then have all that wither away anyways. So at the end of the day, you're not going to spend every dime you have, right? And particularly talking to later, retirement or getting close to retirement, you are not going to you're not going to slide into home plate with $0 left in the bank. You are going to leave your kids something. For a lot of people, you're going to leave them a lot, right? You're going to leave them a lot. That's a whole plan. You want to leave a legacy. But what is that legacy if it's complicated and so much of it is destroyed by not having this done? So just get it done. Right, just get it done. Just pay the money. Doesn't matter. It's going to reduce your end net worth by a tiny bit, but then it's going to smoothly and 95% it will immediately pass to whom you want and avoid the 4 problems. So get it done. And then lastly, communicate with the beneficiaries of your estate plan, with your kids, with whomever. Don't make it a surprise. Don't, if they're saying hey, who's getting what, what you have, it's always an awkward conversation. Kids don't want to bring it up to you. Right? And you don't want to bring it up to your parents. And so many times, people don't, since they don't want to talk about this, don't worry, we've taken care of that. The will is taking care of everything. And then they get the will, they open it up, and it's a total surprise. And then there's still fights and all these things. So don't do that, right? Own up, communicate, have those conversations with your kids, have those conversations with your parents. If they're still alive, make sure that they've done these things. Don't let them saddle you with all these burdens and fights either. Have them watch this. Send this to your parents. If your parents are still alive, send this to your kids. If they've got kids, or they're coming into adulthood or wherever else, wherever you are in the chain, you probably either have someone, parents above you or kids below you that would also need a estate plan. So just send them this video. Say, hey, look, we watched this. It's everything we need to know about estate planning condensed into an hour. You really need to do this. Take action, get it done, and then you have it done, and you don't have to look at it for hardly out. We did a podcast a few weeks ago, called "When Do I Need to Update My Estate Plan?" which we outlined a couple of scenarios where you would actually need to revisit it. But for the most part, it's kind of get it done, and then you don't have to think about it for quite a while. So just get it done. Do it for the children. If you want advice, not legal advice because we can't get legal advice, but if you want estate planning and all these things, right, then get a fee-only fiduciary certified financial planner, right? Someone who can go in, they're not trying to sell you stuff, they're not trying to sell you products or life insurance or any of these other things, right? Because there's tons of people that love to do estate planning because it means they get to sell you a big, giant life insurance policy and they can make a huge commission off that. So you don't want that, right? Work with a fee-only fiduciary. Means they're only acting in your best interest. They're only going to recommend things if it's in your best interest, not theirs. Right? They're not trying to recommend that you go through probate so they can make a whole bunch of money and attorney's fees in the back end. They're going to do what's right for you. And you can find one at feeonlynetwork.com, or of course you can work with us through my financial planning practice, right? RetireMembership, we're just education. We don't do any advice. We don't do any financial planning. But I have another firm. You can go find them, laxfp.com, if you want to work with us. And then lastly, go to RetireMembership.com. We got lots of content, more workshops, podcasts, quizzes, all kinds of good stuff on there just to help you, again, retire successfully and stay successfully retired. So check that out. We're constantly updating it every month. There's multiple things going up there. Visit it, monthly just to see everything that's going on there. Connect with us. If you have questions about this or anything else, you can email us questions@retirementorship.com. We can answer those. Become a Retire Member, where you can get lots of extra bonus content and things like the workbooks, other things like that. Totally free. We don't ask for credit cards. We don't do any of that. And then, of course, listen to the podcast, which comes out each week. Thanks again for investing this time. If you've enjoyed it, like it and YouTube, subscribe if you want more, videos through YouTube come through. We now do our podcast on YouTube. So if you like watching things more than you like listening, you can watch all of our podcasts. And then again, send this link to somebody else. Either we have it on there for someone who's close to retiring, because that's mostly who I work with and who this podcast is geared towards. But of course, if you've got kids that are older, they're not close to retiring, but they've got minor kids, make sure that they have their estate planning done as well. So thanks again for investing the time. I hope this has been helpful for you. Go do those estate planning strategies. You got the notes. I'm not going to remind you again because you should have had the workbook. You have those notes on there. Make sure you go take care of the strategies, nominate the people, get the documents, get it done, and rest well knowing that it's done and you're complete. Thanks again for watching. Cheers.